Okay, so to conclude our conference, I'm very delighted to present our keynote speaker, Professor Owen Fiss, who has kindly agreed to be the closing speaker for our conference. Professor Fiss is a Sterling Professor of Law at Yale University. He was educated at Doctoral, Oxford, and Harvard. He clerked for Third Marshal in the Court of Appeals and Justice Brennan. He also served in the Civil Rights Division of the Department of Justice. Before coming to Yale, Professor Fiss taught at the University of Chicago. Here he teaches procedure, legal theory, and constitutional law, and is the author of many articles and books on these subjects. Today he will speak with us about law in the time of terror. Thank you so much.
It's wonderful to see all of you. I'm very happy to say that although I see many friends in the audience, I don't see any of my students who owe me a JSD dissertation. I have, for many, many years, I taught procedure here, as some of you know, and it was my distinct pleasure to teach first-year procedure on Friday afternoons from 2 to 4 o'clock. That I think really, I loved it, you know. There was no competition with anything. I loved it at least for the students that showed up, because it was no competition with any other activity going on in the law school, save happy hour, which was a new addition. And it sort of enabled me to sort of keep the students after my allotted 2 hours, sometimes until 6 o'clock at night, talking about some fine point of procedure, and they didn't have to run off to another class. But I do admit that the organizers of this conference, and maybe Danny in particular, outdid themselves by having me speak at 5:30. Sometimes I had a great difficulty convincing my family that I was just going out to give a lecture. So forgive the hour, sit back and relax. I'm sure we'll be finished by at least 8:30 or 9. In the fall of 2001, and in response to the terrorist attacks that occurred on September 11th, President George Bush declared a war on terror. Although the phrase, the war on terror, has no discernible legal content and was conceived by President Bush for political purposes as a way of mobilizing the nation, the phrase has come to embrace 3 distinct military operations, each of which can properly be considered a war. One is against Al-Qaeda, the international terrorist organization responsible for the attacks that occurred on 9/11. A second war consists of the military campaign against Afghanistan, then ruled by the Taliban, for harboring Al-Qaeda. The third is against Iraq, then controlled by Saddam Hussein. Although Saddam Hussein had no role in the 9/11 attacks, the administration justified the invasion of Iraq on the theory, soon disproved, that Saddam Hussein possessed weapons of mass destruction. Yet the American troops that invaded Iraq in 2003 and then occupied the country became the target of terrorist attacks, some by Al-Qaeda, and that had the effect of turning Iraq into yet another site of the so-called war on terror. The military campaign in Iraq ended in December 2011, when the United States withdrew its forces from that country. Plans have also been set for the withdrawal of troops from Afghanistan by the end of 2014. And if these plans materialize, the war against Afghanistan will then be concluded. In recent years, the Taliban has been treated as a distinct belligerent apart from Afghanistan, but as an ally of al-Qaeda, and as a consequence, the war against the Taliban continues. So does the war against al-Qaeda. In May 2011, Osama bin Laden, the self-declared leader of al-Qaeda, was killed by a group of Navy SEALs who in the middle of the night had penetrated his compound in Pakistan. Bin Laden's death did not, however, bring the war against al-Qaeda to an end. In fact, the military campaign against al-Qaeda remains, as it has always been, the focal point of the war on terror. Although President Barack Obama has avoided speaking of a war on terror, he has repeatedly declared that the United States is at war with al-Qaeda and its allies. Just this past May, apparently in response to the deteriorating situation in Guantanamo, a hunger strike that at its peak involved more than 150 prisoners, Obama delivered a speech at the National Defense University in which he openly contemplated the end of the war against al-Qaeda. This war, he said, like all wars, must end. However, in July and August, he launched drone attacks in Yemen and Pakistan against suspected members of al-Qaeda and the Taliban, and in so doing, he indicated a willingness to continue, maybe even intensify, the war that had been launched against al-Qaeda and its allies more than 12 years ago. This war, as well as the wars against Iraq and Afghanistan, has raised countless legal questions. Maybe that's true of every war. War summons the power of the nation, and in so doing puts at risk the many norms that seek to restrain the government power. As a result, over the last 12 years, numerous lawsuits have been launched to contest policies pursued by the government in conducting the war on terror. These lawsuits have been based on a variety of laws, including statutes, international treaties, and the Constitution itself. At the center of my concern are the claims charging the government with violating the Constitution, for the Constitution is the most basic law of the nation. Not only does the Constitution define the political order and shape our national identity, it also commands absolute respect from every officer who exercises the power of the United States. Some of these officers might contest an interpretation of the Constitution, even one rendered by a court, including the highest, but no government official is likely to acknowledge that he has violated the Constitution, even if he might be able to justify his actions in terms of military necessity. Although many of the federal courts throughout the nation, both at the trial and appellate level, have been engaged in the lawsuits prompted by the war on terror. My focus is on the Supreme Court's response to these lawsuits. The Supreme Court sits at the apex of the federal system, and we often look upon it as having a special responsibility to protect the Constitution. In confronting earlier wars, the court has sometimes stumbled to engage in an understatement when asked to judge the action of the political branches. Think for a moment of Karamazov and the Supreme Court's willingness to uphold the program of relocating persons of Japanese ancestry, including American citizens from the West Coast. This historical experience may have lowered our expectations and led many, many to celebrate the edicts issued by the Supreme Court when in judging the government's conduct on the war on terror. I have, however, an entirely different view of the matter. My mood is not one of celebration. Over the last 12 years, the Supreme Court has been repeatedly asked to hold a government to the terms of the Constitution. But much to my disappointment, the court has balked and dismissed these lawsuits without reaching the merits or responding to the merits in a fractured or evasive manner. In doing so, the court has undermined the system of accountability that has, over the second half of the 20th century, become a proud part of our constitutional tradition. At issue, I claim, is not a single isolated decision of the Supreme Court, but rather a pattern of decisions that is at once persistent and corrosive, and in my judgment, constitutes a gross dereliction of duty. To sustain this charge, I need to analyze the performance of the Supreme Court during the post-9/11 era in 4 discrete areas. The first consists of the decision this past February when the Supreme Court dismissed, without ever reaching the merits, a lawsuit attacking a grant of authority by Congress for the executive to engage in warrantless wiretapping. The statute in question enacted in 2008 and renewed in 2012 was intended to supplant the secret order President Bush had issued in the fall of 2001, authorizing the National Security Agency to intercept, without court authorization, the international telephone calls of anyone suspected of having links to Al-Qaeda. The lawsuit against the 2008 statute was brought by a varied group of individuals. Some were lawyers representing suspected terrorists about to be tried. Others were journalists who regularly cover the Middle East and the government's counterterrorism activities in that region. Still others were researchers for NGOs such as Amnesty International that are dedicated to the protection of human rights. Because of the secretive nature of the threatened interception, none of these individuals could show that the government was in fact tapping their telephones. They claimed rather that there was a substantial risk that the government was doing so, and that the grant of authority contained in the 2008 statute for the executive to engage in such surveillance violated the Fourth Amendment. Although in one footnote, the Supreme Court, for reasons that are very difficult for me to understand, declared that the risk of interception that the plaintiffs faced was not substantial. The larger ambition of the court's opinion, written by Samuel Alito, was to craft a new standard for standing in national security cases. In such cases, he said, the plaintiffs have to show that the harm that they are complaining of was certainly impending. Such a standard, the certainly impending standard, would in fact render a surreptitious program of surveillance, like warrantless wiretapping, virtually immune from judicial review. Justice Alito did not deny this possibility, but rather declared an indifference to it. A second dereliction of duty arises from the Supreme Court's decision on military commissions. In the past, the United States had used military commissions to try war crimes. Typically, such tribunals were convened in an active theater of combat by a commanding officer who appointed the officers that were to conduct the trial. The jurisdiction of these tribunals extended to the nation's own troops as well as enemy soldiers. Under these conditions, military commissions were viewed as tribunals of necessity, as a way of preserving the integrity of the laws of war in the midst of an ongoing conflict. At the very beginning of the War on Terror, President Bush issued an order establishing military commissions to try some of the prisoners held at Guantanamo. These commissions were to be composed of military officers appointed on an ad hoc basis by an official in the Department of Defense. The procedural protections to be afforded the accused were significantly less forceful than those available in civilian courts. It was also contemplated that the public's access to these trials would be limited. President Bush, however, broke from the fast because whatever else might be said about Guantanamo, it was not an active theater of combat. In another departure, Bush confined the jurisdiction of the Guantanamo commissions to foreign nationals, a circumstance that not only offended equal protection, but also underscored the lesser quality of the justice likely to be rendered by these tribunals. It was not good enough for Americans. In June 2006, the Supreme Court rendered a decision, boldly celebrated in the headlines, that held invalid Bush's order establishing the military commissions at Guantanamo. In truth, however, the court said nothing about due process. It held only that Bush's order violated a provision of the Uniform Code of Military Justice that required the procedures of military commissions to approximate those of courts martial. Congress almost immediately and quite predictably responded to the Supreme Court's decision by enacting the Military Commissions Act of 2006. It in effect endorsed Bush's initial order and put the use of military commissions to try war crimes committed by foreign nationals on firm statutory grounds. The 2006 statute was further refined by the Military Commissions Act of 2009, a measure that President Obama sponsored and that was aimed at improving some of the evidentiary rules governing military commissions. Obama's revisions were wholly salutary, but they did not eliminate the affront to due process that adheres in the adjudicatory structure created by the use of military commissions. This structure vests in military officers the power to decide the fate of suspected terrorists who are foreign national. It allows a Department of Defense official to select on an ad hoc basis the officers vested with the power to try these individuals. And it empowers the executive to use these tribunals whenever it perceives some advantage might be gained. To this day, the Supreme Court has not addressed the due process issued by this adjudicatory structure, although the Obama administration has convened 2 military commissions, which are now busy at work at Guantanamo. A third area of dereliction concerns the failure of the Supreme Court adequately to address the claim advanced by both President Bush and Obama that the government has the authority to incarcerate members of Al-Qaeda and the Taliban for prolonged, indefinite periods, maybe for life, without ever charging these prisoners with a crime or bringing them to trial. Bush and Obama have sought to justify this policy as the traditional prerogative of a belligerent that allows a nation to imprison enemy combatants for the duration of hostilities. In doing so, they failed to recognize the unusual nature of the war on terror. The military operations that it contemplates may go on forever, and the danger to personal freedom that would arise from the application of the traditional prerogative of a belligerent to such a war. In June 2004, the Supreme Court ruled that an American citizen, Yasser Hamdi, who had been captured in Afghanistan in 2001 and then incarcerated in a naval brig in the United States, was entitled as a matter of due process to an evidentiary hearing on his claim that he had been in Afghanistan for purely personal reasons and in fact had not taken up arms against the United States. Although the court's ruling was heralded as a victory for due process, it was qualified in important ways when the moment came to fashion the procedural rules that would govern the evidentiary hearing, such as those allocating the burden of proof. The author of the court's opinion, Sandra Day O'Connor, even went so far as to suggest that the required evidentiary hearing could be held before a military tribunal. Yasser Hamdi was captured in Afghanistan. In a companion case, the court was confronted with the habeas petition of an American citizen, Jose Padilla, who had been captured in the United States. He was initially arrested at O'Hare Airport in Chicago in May 2002. He's transferred to New York and held by civilian authorities there under a material witness warrant. In the middle of the night, and without consultation to counsel, he was transferred to military authorities and sent to a naval brig in South Carolina. In a press release issued on his arrest, the Attorney General claimed that Padilla was an operative of Al-Qaeda who had been sent to the United States to detonate a radioactive device. Padilla was not charged with that crime nor any other crime. By the time his habeas petition reached the Supreme Court, Padilla had been in prison for 2 years and for the most part held incommunicado. Yet the court did not address the legality of his imprisonment. Instead, it ruled that Padilla's lawyers had erred when they filed his habeas petition in the federal district court in New York, as opposed to the one in South Carolina, where he was then being held. Because the transfer from civilian to military authorities occurred surreptitiously, it is unclear whether the decision of Padilla's lawyers to file the petition in New York was in fact an error. Even if it were, this error in no way would affect the capacity of the Supreme Court to speak to the merits of Padilla's claims or the legality of the government's detention policy. Following the court's dismissal, Padilla's lawyers indeed did file a new habeas petition, this time in South Carolina. In this second habeas proceeding, the court ruled in Padilla's favor, the district court ruled in Padilla's favor. The government then decided to forego the opportunity to seek review in the Court of Appeals and directly petition the Supreme Court. Once again, the Supreme Court did not rule on the merits of the case, but rather directed the parties back to the Court of Appeals, which in due course reversed the district court and ruled in favor of the government. At this juncture, Padilla's lawyers sought review of the Court of Appeals decision and the legality of the client's detention. Just days before it had to respond to Padilla's petition for certiorari, the government sharply reversed course. The government finally charged Padilla with a crime, specifically for conspiring to murder, kidnap, and maim persons in a foreign country, and also for providing material support to terrorists. No mention was made of a plan to detonate a radioactive device in the United States. In the face of this new turn of events, the government asked the Supreme Court to deny Padilla's petition for review and to vacate the judgment of the Court of Appeals as moot. In January 2006, the Supreme Court granted the government's motion and dismissed Padilla's certiorari petition. In so doing, the Supreme Court avoided confronting the government's brazenly evasive strategy and failed to judge the legality of the government's detention policy. By this time, Padilla had been in prison for 3.5 years without ever being charged with a crime. In 2007, Padilla was eventually tried in a district court in Florida. And in August of that year, he was convicted of the charge, of the crimes that were charged. Some months later, he was sentenced to 17 years in prison. While his trial was in process in the district court in Florida, Padilla and his mother, Esther LeBron, filed a suit in the district court in South Carolina against Donald Rumsfeld and other national security and defense officials. The complaint alleged that Rumsfeld and the other defendants had violated Padilla's constitutional rights by declaring him an enemy combatant and subjecting him to prolonged, indefinite imprisonment without trial. The complaint sought nominal damages from the defendants. The district court dismissed the suit, and the Court of Appeals affirmed that judgment. LeBron and Padilla sought review of this judgment. The Supreme Court denied their petition, and once again, refused to review the legality of the administration's detention policy. Jose Padilla and Yasser Hamdi was, as I noted, United States citizens imprisoned in the United States. One was captured in the United States, Padilla, the other in Afghanistan, Hamdi. A third decision rendered in June 2004 involved foreign nationals who were being held in Guantanamo, a 45 square mile territory on Cuba that the United States had occupied since 1903 and had, in January 2002, turned into a prison for the war on terror. The United States had obtained the lease for that territory as a result of the Spanish-American War. In the lease, Cuba nominally retained some sovereignty, but it gave the United States the right to occupy Guantanamo for as long as it wished. The question raised in this case was whether the Guantanamo prisoners were entitled to the protection of the writ of habeas corpus. The Constitution explicitly limits the circumstances under which Congress might suspend the writ, and in so doing, implicitly guarantees the writ when those circumstances have not been met. President Bush maintained, however, that this provision was of no avail to the Guantanamo prisoners. The Court of Appeals for the District of Columbia sustained his position, reasoning, and I quote, "We cannot see why or how the writ may be available to aliens abroad when basic constitutional rights are not." Over the next decade, the Supreme Court did everything possible to avoid ever confronting the logic of the Court of Appeals decision. In June 2004, in a companion to the Hamdi and Padilla decisions, the court avoided the constitutional issue and simply held that by its very terms, the federal statute governing habeas corpus was broad enough to allow the Guantanamo prisoners to apply for the writ. In December 2005, Congress, responding to that decision, amended the federal habeas statute and explicitly denied the Guantanamo prisoners the right to apply for the writ. This statute was not a suspension, but rather an outright prohibition on access to the writ, and raised obvious constitutional issues because the prohibition was restricted to one group of prisoners and was not predicated on the circumstances that otherwise would allow Congress to suspend the writ. When the validity of the 2005 statute arose before the Supreme Court, as it did in June 2006, the court, once again guided by the tenets of minimalism, avoided ruling on its constitutionality. The court simply held that the statute was not meant to apply to habeas petitions that had been filed before the statute had been enacted but was still pending. In October 2006, Congress passed another statute denying the writ of habeas corpus to any foreign national, regardless where he was incarcerated, who the executive had determined was an unlawful enemy combatant. By way of emphasis, Congress declared that this ban on habeas corpus was to apply to all pending cases, quote, without exception. This long saga over the availability of habeas corpus to the Guantanamo prisoners eventually came to an end, hooray, in 2008, more than 6 years after the prison in Guantanamo had been opened. In June 2008, the court held in Bermudine versus Bush that the ban on habeas enacted by Congress in 2006 was invalid, at least as it was applied to the Guantanamo prisoners. The court did not overrule the bold declaration of the Court of Appeals, which had originally sustained Bush's position. The court did not repudiate the bold declaration of the Court of Appeals that denied that the Guantanamo prisoners had any constitutional rights. Rather, the court decided that the ban on habeas was an affront to the principle of separation of powers. According to Justice Anthony Kennedy, the author of the court's opinion in Bermudadine, the statute denied the judiciary the power to determine the legality of the executive's action and thus disturb the allocation of powers provided for in the Constitution. On this theory, on Kennedy's theory, the only issue to be decided in the habeas proceeding was whether a prisoner being held at Guantanamo had supported al-Qaeda or the Taliban. There was no indication that the prisoners would be able to use habeas to challenge trial by military commission, or to challenge prolonged indefinite imprisonment without trial, or even to challenge their detention on the ground that they were being held, that they were being or had been tortured. The court also failed to give any guidance to the lower courts regarding the evidentiary rules to govern these habeas proceedings. Nor did it lay down a principle for determining whether habeas would be available to prisoners who were confined to other offshore prisons established by the executive as part of the war on terror. The Guantanamo prisoners had the benefit of Bermudadine, which Bush, of course, obeyed, as did Obama. However, soon after taking office, Obama took the position, subsequently affirmed by the Court of Appeals, that the prisoners at the Bagram Air Force Base in Afghanistan were not entitled to have the legality of their imprisonment reviewed through habeas. At that time, there were almost 800 prisoners at Bagram, which, like Guantanamo, had been used to incarcerate suspected terrorists who had been brought there from all four corners of the earth. The fourth and final area of Supreme Court practice that is the source of my disappointment concerns torture. When the war on terror began, a broad array of legal instruments, including a treaty, a criminal statute enacted to implement that treaty, and above all, the Fifth and Eighth Amendments of the Constitution, rendered illegal torture by United States officials. The Eighth Amendment prohibits cruel and unusual punishments, and the Fifth Amendment's due process guarantee had long been construed to prohibit police practices that are shocking to the conscience. In the period immediately before 9/11, often seen as the triumphant moment in the history of human rights, most American lawyers proudly assumed that United States officials would obey these laws and never engage in torture. Starting in April 2004, however, with the publication of photographs depicting abuse of prisoners at the Abu Ghraib prison in Iraq, that assumption was shattered, and the concern grew that American interrogators were using torture. This concern soon deepened, maybe even turned to alarm, when internal government documents of the Department of Justice and the Department of Defense, originally prepared in 2002, were leaked. These memorandum were aimed at loosening the constraints on interrogators and legitimating practices such as waterboarding, almost universally thought to be a form of torture. It soon became abundantly clear, or to use the euphemism coined during this period, this dark euphemism, enhanced interrogation, had become an integral part of the war on terror. In December 2005, Congress, acting at the prodding of Senator John McCain, a victim of torture during the Vietnam War, passed a broad statute prohibiting torture by United States officials. President Bush forcefully campaigned against enactment of the statute. Eventually, he signed it into law, but when he did, he issued a statement underscoring the fact that the statute provided no remedy to those who may have been tortured. In the signing statement, Bush also declared that he would not let McCain's proviso interfere with the discharge of his duties as Commander-in-Chief. In his memoirs, published soon after leaving office, Bush reported, or better, proudly declared, that he had personally authorized the waterboarding of one of the leaders of Al-Qaeda. Upon becoming president, Barack Obama immediately issued an executive order banning torture. He also took 2 additional steps, making it less likely that the United States interrogators would torture suspected terrorists. He made the CIA subject to the Army Field Manual, and he closed the CIA's secret overseas prisons, the so-called black sites. Obama, however, steadfastly refused to prosecute any official who might have engaged in torture. He also refused to establish a truth commission that might set the record straight or return torture to the realm of the forbidden. President Obama said he was not interested in the past, only in the future, without understanding that what occurs in the future will be partly governed by how one deals with the past. Faced with this default, the victims of torture turned to the civil law and sought to recover on their own damages from the officials who were responsible for their abuse. These plaintiffs, 3 of which are most notable, relied on a 1971 decision of the Supreme Court, the same one that had been invoked by Padilla and his mother, that allowed individuals directly, without the need for statutory authorization, to sue for damages arising from the violation of their constitutional rights. All 3 cases involve the practice of extraordinary rendition, in which persons in the custody of the United States were sent to countries such as Egypt and Syria for interrogation under circumstances that made it very likely that they would be tortured. The fact that the torture was outsourced to foreign officials did not relieve the United States officials of responsibility for the torture that ensued. For it was the United States officials who sent the individuals abroad, and who did so for the purpose of having interrogators in those countries inflict the pain needed to obtain information that was of value to the United States. In each of these 3 cases, the lower courts dismissed the complaints without ever reaching the merits of the claim. 2 were dismissed on the ground that the factual inquiries involved in the lawsuits would present an unreasonable risk of revealing state secrets. The 3rd was dismissed on the ground that special factors, namely that the case involved military operations and the conduct of foreign affairs, warranted exception to the 1971 precedent upon which the plaintiffs relied. In all 3 cases, the individuals subjected to rendition and torture sought review by the Supreme Court through the writ of certiorari. And in each case, the Supreme Court declined to review the judgments of the lower courts. The certiorari jurisdiction of the Supreme Court is in fact discretionary. In part, it reflects the impossibility of having the Supreme Court review all the judgments of the lower courts. A conflict among the lower courts often acts as an especially compelling reason for the Supreme Court to grant the writ of certiorari. There was no such conflict in these cases, but there were other compelling reasons for the court to consider them. Although the lower courts had relied on earlier Supreme Court rulings in dismissing the suits, in each instance the lower court extended those rulings and applied them in a totally different context. Moreover, in all three suits, United States officials were charged with being responsible for conduct, interrogation, and the conditions of torture that appeared to be a pervasive feature of the War on Terror and that challenged what was once a proud feature of the United States constitutional tradition. As with warrantless wiretapping, as with military commissions, as with imprisonment without trial, the Supreme Court's unwillingness to confront the issue of torture left the individuals who had claimed to have been tortured without a remedy or even without a hearing on their claim. There is every reason in the world to be moved by their plight, but my concern here, as with the other decisions I just described, is not so much with the injustices done to these individuals as is with the breakdown of the system of accountability that these decisions represent. The tripartite division of the government into executive, legislature, and judicial often leads to easy talk about checks and balances and a vision of the judiciary as a check, or better yet, a counterweight to the political branches. In my view, however, such a conception of the judiciary's role in the American political system, or for that matter in any democracy, is misleading. The function of the judiciary is not to balance or check or temper the action of the political branches, but rather to interpret the Constitution and determine whether the other branches have complied with it. The court's judgment may constrain the political branches and in that way act as a check or a counterweight, but that is not necessarily so. Sometimes the court may legitimate or facilitate the action of the political branches. And even when it nullifies or sets aside that action, the constraint on the political branches emerges as a consequence of the court's judgment about the legality of the action. My complaint is not in the broad array of cases I've described: warrantless wiretapping, the use of military commissions, imprisonment without trial, and torture, that the court failed to check the executive or legislature or otherwise failed to act as a counterweight. Rather, my claim is that it failed adequately to determine the legality of these practices. In a recent book, Jack Goldsmith of Harvard points to the constraints that have operated on Bush and Obama over the last decade in the formulation and implementation of the counterterrorism policies. Professor Goldsmith acknowledges the role the judiciary played in this process, but he does so grudgingly, and for the most part views the lawsuits that have been launched as little more than a means that enable various NGOs to air their views. It matters little to Goldsmith that the lawsuits that these organizations had filed were dismissed, or that the Supreme Court responded to their claims in a limited and, in my view, unsatisfactory way. In describing the constraints on Bush in the post-9/11 era, Goldsmith's primary emphasis is not on the judiciary, but on Congress and a host of institutions such as the media and the NGOs that might properly be considered part of civil society. They shape public opinion and in that way influence the action of the president and Congress. One of Goldsmith's aims is purely descriptive, to describe the emergence during the post-9/11 era of a broad and varied system of constraints that have operated on the president and in his conduct of the war on terror. As part of this descriptive endeavor, Goldsmith introduces the concept of the presidential synopticon, which turns out to be a reversal of the plan for penitentiaries, the panopticon, that had been made famous in our time by Michel Foucault, which was originally conceived by Jeremy Bentham. Bentham envisioned locating jailers in a watchtower so that they could look into the cells of each inmate, all of whom were arrayed in a circle around the tower. The gaze of the jailers, according for Bentham, was the source of their power. Under Goldsmith's scheme, that is, under the presidential synopticon, the gaze is reversed, or better yet, multi-directional. So is the flow of power. The president is in the tower and continues to exercise power over the public, but at the same time, he is watched and thus constrained by all the political agents and forces arrayed around him. It should be stressed, however, that Goldsmith's purpose is not merely descriptive, but also has a normative or even a jurisprudential dimension. Professor Goldsmith's aim is not merely to introduce the presidential synopticon and to demonstrate that Bush and Obama have been constrained by it in adopting and formulating their counterterrorism policies. His larger purpose is to maintain that by virtue of these constraints, the counterterrorism policies that have evolved over the past decade or so, which have been generally referred to as the new normal, should be viewed as legitimate and even more lawful. In reaching the startling conclusion, Goldsmith relies on a political or evolutionary conception of law. In deeming the new normal legal or constitutional, he assumes that it rests upon a popular consensus, when in truth that so-called consensus is nothing more than a reflection of the current distribution of power between conflicting and antagonistic forces. Goldsmith erred in inferring consensus from stasis. One can also object to Goldsmith's view on the ground that it provides no basis for determining the legality or constitutionality of various practices prior to the achievement of consensus. Although someone can always complain that the president's or Congress's actions are abusive or excessive, the critic can give no legal content to their terms, since according to Goldsmith, what is constitutional is nothing more than what happens to evolve from political struggles. An even more fundamental objection to Goldsmith arises from his conflation of popularity with legality. For Goldsmith, what is constitutional is simply what the demos, or the relatively more influential or powerful group that control it, eventually come to accept as legitimate. I, however, start with another and more transcendent conception of the Constitution. I view it, perhaps as most lawyers do, as the charter of the nation that establishes the structure of government and the principle that should guide government officials in the discharge of their duties. These principles need to be interpreted and applied in concrete context, but neither these principles nor their interpretations are made subject to the vagaries of popular opinion, even if that opinion is assumed to evolve into that mythical entity imagined by Goldsmith, a consensus. In saying this, I do not mean to suggest that the judiciary has an exclusive right to interpret the Constitution. The political branches, indeed all powerful social actors, have an obligation to determine whether their action comports with this broad charter of governance. Sometimes, as occurred during the War on Terror, the political branches have been derelict in discharging this duty, and this dereliction of duty has made the intervention of the court all more compelling. Such a disregard of the Constitution was evident in the decisions of the executive to utilize waterboarding and other interrogation techniques almost universally condemned as torture. Although the lawyers within the executive branch, such as John Yoo and William Haynes, wrote lengthy legal memoranda defending the legality of such interrogation techniques, their memorandum were designed to tell the President and Secretary of Defense what they wanted to hear, not to provide an independent assessment of the law. The failure of the political branches to properly and seriously consider the legality of their actions was also manifest in Congress's decision in 2006 to deny the writ of habeas corpus to any foreign national determined by the executive to afford on behalf of Al-Qaeda or the Taliban. Senator Arlen Specter, head of the Senate Judiciary Committee and a distinguished graduate of this distinguished lawsuit, concluded that the ban on habeas corpus embodied in the bill was unconstitutional, but in the end, he voted for it. He left it to the court to invalidate the statute, which it in fact did 2 years later in the Bermuda Dean case, though not in a manner worthy of a court of law. Let us assume, however, that the examples I just described are aberrations, and that the President and members of Congress have made a serious and good faith judgment about the constitutionality of each measure in question. Arguably, this may have been the case with the 2008 statute that authorized warrantless wiretapping, since the grant of power was limited to cases where the target was a foreign national located abroad, and a significant purpose of the wiretap was to obtain foreign intelligence. I would nonetheless maintain that this judgment by Congress and the President did not lessen the need for the Supreme Court to judge the validity of the statute or excuse the recent decision of the court dismissing for lack of standing a lawsuit challenging the statute, or even more, to express, as Justice Alito did, an indifference to whether the constitution of the statute could ever be reviewed by the court. In saying this, I'm drawing a distinction between exclusivity and authoritativeness. The court is not the only institution that can interpret the Constitution, but is the only one that can give it an authoritative interpretation. The authoritativeness of the court's interpretation does not derive from the personal qualities or moral character of the individuals who happen to be sitting on the bench. Rather, it stems from their political insularity and the fact that the exercise of judicial power is governed by what I have elsewhere called the strictures of public reason. The judiciary must hear from all aggrieved persons. It must openly address the arguments made by these persons. It must publicly announce its decision, and it must justify that decision on the basis of principle. The judiciary's independence from politics and its adherence to the strictures of public reason are instrumentally connected to arriving at the right interpretation. In other words, these limits on the exercise of the judicial power make it more likely that the judiciary, as opposed to the executive, or the legislative branch, or even some popular assembly, will correctly interpret the Constitution, although they do not guarantee it. Mistakes are always possible. If, however, the issue is not whether the judiciary has reached the right answer, but rather whether its answer is the authoritative one, then the judiciary's political insularity and its adherence to the strictures of public reason play a constitutive as opposed to simply an instrumental role. When it comes to interpreting the Constitution, the judiciary can override an interpretation of the political branches and claim that its view is authoritative simply by virtue of its political insularity and its willingness to abide by the strictures of public reason. This authority, however, does not create a privilege for the judiciary to abstain from rendering judgment on the law whenever it deems abstention appropriate. While the Supreme Court must control its docket through the exercise of certiorari to avoid being swamped by an overload of cases, it has a responsibility to address practices employed in the war on terror, such as extraordinary rendition, that offend the most elemental principles of the Constitution. The duty arises from the court's place within the structure of government as the guardian of the Constitution and its unique capacity to generate authoritative interpretation. In some instances, for example, when the court denied plaintiffs standing to challenge a 2008 statute authorizing warrantless wiretapping, or when in January 2006 the court dismissed as moot Jose Padilla's challenge to the executive's policy of prolonged indefinite imprisonment without trial, the court based its decision on the Article 3 case or controversy requirement. In those cases, the court was interpreting the Constitution, Article 3. Granted, those interpretations are authoritative, but I also maintain that they are mistaken. The mistake arises from the court to recognize fully its unique function in the system of government and to need to hold the political branches accountable to the law. In faulting the court for deciding to abstain from a judgment on the merits, we should not assume that if the court in fact had reached the merit, it would have deemed the contested practice unconstitutional. The court, for example, might have found a way to sustain warrantless wiretapping as an appropriate counterterrorism tactic, or to allow imprisonment without trial as a prerogative of a nation at war, or to reject the due process objection to using military commissions to try Guantanamo prisoners. Such decisions on the merits would be mistaken and on the best of days seem highly unlikely, but they cannot be ruled out altogether. Seen in this light, we must compare two grisly alternatives: no decision on the merits, or a bad one. And I would contend that the first alternative, no decision, is the more disagreeable one. Not only does it constitute a dereliction of the court's duty in our constitutional system, but it also allows the contested practice to continue, at least for the time being, in a particularly unfortunate way. It relieves the court of the responsibility for the continuation of the practice, and it deprives the public and bar of the opportunity to critically examining the reason rendering the practice constitutional. As the eventual fate of Korematsu indicates, such critical examination is essential to the life of the political system and to the growth of the law. The majority decision by Hugo Black and Korematsu was a bad one, but better than the one proposed by Robert Jackson, not saying anything. The reluctance of the Supreme Court to review the work of the political branches does not operate across the board. Indeed, Justice Ruth Bader Ginsburg, in a recent interview with the New York Times, labeled the current Supreme Court as one of the most activist in the court's history. In making this charge, Justice Ginsburg primarily had in mind the Supreme Court's recent decision in Shelby County, invalidating a crucial provision of the Voting Rights Act of 1965. So we must ask ourselves, what distinguishes such a case from the ones arising from the war on terror that I have described in this lecture. True, the court has long deferred to the political branches in cases involving military operations and the conduct of foreign affairs, but that itself is a distinction that requires justification. Some have sought to justify the selective deference of the Supreme Court in terms of expert knowledge. The idea is that military operations and the conduct of foreign affairs requires expertise that the judiciary does not possess. In truth, the knowledge required in these areas is no more impenetrable or complex than the knowledge required in reviewing other activities of the modern state, for example, running a school system or a prison or a police department. Moreover, the judiciary's task in all these cases is not to second-guess the executive or the legislature branch on factual matters or to make a judgment about the best policy for the nation. The judiciary's task is only to determine whether the Constitution has been violated. Surely not a matter that lies within the expertise of Congress or the military or the diplomatic corps or the executive branch in general. In making the judgment whether the executive branches have respected the bounds of the Constitution, the court can assume that the factual predicates underlying the action of the President or Congress are correct and that the challenged policy or action serves the public interest. The court may assume that there is a need for unfettered power to wiretap, or that the suspected terrorist possesses useful or highly valuable information, and that the imposition of excruciating pain, depriving him of sleep, simulating the sensation of drowning, chopping off a finger, will lead the prisoner to yield the much-needed information. The court can assume all of this is true, but then it must proceed to the more normative judgment of determining whether the Constitution permits such action. The judgment of the court may, of course, prevent the political branches from pursuing the policy that they deem best. That constraint will flow, however, from the Constitution and the authority of the judiciary to interpret it, not from the judiciary's disagreement with the judgments of the political branches about the facts or the public interest. Aside from any claim of expert knowledge, deference to the political branches in cases involving military operations or foreign affairs might be justified in terms of the harm that is threatened. The fear is that a judicial decision constraining the political branches, even if the constraint is fully justified by the Constitution, might result in catastrophic harm. And that in such a situation, the first priority should not be legality, but rather power, the power that is needed to avoid this catastrophic harm. We usually associate the risk of catastrophic harm with wars, and thus we may well assume that the war on terror, or more specifically the war against Al-Qaeda and its allies, is impelled by a desire to avoid such harm. However, as we have learned over the last decade, there are different types of wars, and the interest at stake in each type varies. Some place the very existence of the nation in jeopardy, as was indeed true of the Second World War, the context of Karamazov. In fighting such a war, a strong case might, and I say only might, be made that power precedes legality, not the other way around. I do not believe, however, that the military campaign against Al-Qaeda and its allies is a war of this type, or that the activities of these terrorist organizations pose a threat to the existence of a nation. To draw a distinction between a war that poses an existential threat to the nation and a war against a terrorist organization such as Al-Qaeda, and in this way resists the reversal of the relationship between power and legality, is not to minimize the harm that terrorists can inflict. The death and destruction that occurred on 9/11, or that occurred in Madrid, or London, or in Kenya just a month or two ago, testifies to the magnitude and severity of the harm that can be wrought by the hands of terrorists. Indeed, some have said that the loss of lives and the destruction of property on 9/11 was even greater than that which occurred at Pearl Harbor on December 7th, 1941. The harm inflicted by terror should not be measured only in material terms. We should also take into account the fear that terrorist attacks arouse in the entire civilian population. You never know when or where the next attack will take place and whether you might be a victim of it. The production of such a fear is indeed one of the defining features of terrorism. It consists of violence aimed at terrifying a civilian population. Until 2012, the fear engendered by the 9/11 attacks was constantly renewed by periodic red or orange warnings issued by the executive. Now, the 24/7 news cycle has the same effect. This element of fear provides additional reason to guard against such attacks and to suppress organizations such as Al-Qaeda that may be responsible for them. It also, and this is crucial, it also gives us an additional reason to be distrustful of popular sentiment or the judgment of the branches of government responses to that sentiment when choosing the means that should be used to fight terrorism, and even more when deciding which of those means are lawful. Popular sentiment is always an uncertain guide to legality. And this is especially true when it is shaped by fear. Fear drives the perspectives of individuals inwards to their own physical well-being or to the well-being of their loved ones, and often prevents individuals from thinking as rationally or as intelligently as they otherwise might. It also prevents them from fully appreciating the values that are embodied in the Constitution and that define us as a nation. Of course, judges are subject to these same psychological dynamics. They too have been in the grips of fear engendered by the 9/11 attacks and all the other attacks that occurred over the past 12 years. But judges are subject to the strictures of public reason. Above all, the need to publicly announce their decisions and to justify them on principle. And we can hope, maybe we can even assume, that through this discipline, judges will work their fears and view the issue, work through their fears and view the issues before them in a dispassionate or reflective manner. Indeed, in this time of terror, the judiciary might be uniquely capable of the impartial judgment that is of the essence in the law, is the essence of the law, and that is needed to hold the government accountable to the law. Thank you.
We have a couple minutes for public questions.
more specifically then, you mentioned Bagram Air Force Base and prison. I'm wondering to what extent you think there is a defense for habeas being granted to prisoners there, or not?
Well, I think there's only one constitution, a constitution that governs in peace and war, and a constitution that governs in New Haven, Guantanamo, or Afghanistan. I do think the meaning of the Constitution varies in each of those settings. And what constitutes due process in New Haven may be different than what constitutes process in Guantanamo, and what constitutes process in due process in Guantanamo may be different than what occurs in an active theater of war. I think the interesting point to keep in mind is that although Bagram is located in Afghanistan, it was not used simply as an adjunct to the active hostilities that were occurring in Afghanistan. As I emphasized in my remarks, it was also used as sort of a dumping ground for suspected terrorists that were captured in Bali, Algeria, the Balkans, wherever you want. So, the district court in the case that involved Bagram made that distinction and said habeas should be available to all of these people under the terms of Bermudadine. If there are Afghanistan prisoners that are still, this is part of the active theater of war, perhaps habeas would not be available to them. I'm not sure about that judgment, but that was following the Bermudadine criteria. I do think, just getting a little to the heart of your question, I do think that in an active theater of war, the government is entitled to target enemy combatants without first giving them a trial. So what constitutes a due process in an active theater of war is different than what occurs in New Haven, Guantanamo, or get a little closer to the heart of your question, Yemen. I do think that our targeting practices are governed, the targeted killing of suspected terrorists is governed by due process, and that due process yields a number of sort of dictates or principles or standards that govern targeting in Afghanistan, the active theater of war, or that govern targeting in Yemen, or that engage in targeting in Guantanamo or New Haven. So I have a very unitary conception of the Constitution. I think the Constitution establishes the standards of conduct, the norm of all government officials, no matter what they are, but their application depends a lot upon the situation in which it occurs. I mean, I think the prior to Bermudadine, I think the Bush administration primarily took the view that it didn't restrain the government in any of its activities abroad, and Guantanamo happened to be such an activity abroad. And what's sort of disturbing to me, which is more the theme of this lecture, is that the Supreme Court over these last 12 years never confronted that, or that's been one of the central issues posed by the war on terror.
So, if there are no other questions, please join me in thanking Professor Fiss.